we have Erica and Allison, and Erica is a lawyer specializing in IP in life sciences with a focus in biotechnology and pharmaceuticals. This slide is exactly from ChatGPT. And you are also the founder of Ingensity, a legal startup with a new model for providing IP assessment and strategy for life science companies. Allison here is the first director of the new Berkeley Center for Law and Technology. And she's worked as a law clerk with the United States District Court in New Jersey and also the U.S. Court of Appeals in the Federal Circuit. In both your roles, you were focused on biotech and life sciences as part of your clerking. Did I get that right?
Yeah, so we actually, the Berkeley Center for Law and Technology has a bunch of centers in it. I direct our Life Sciences Law and Policy Center. But yes, I did work for federal judges and did lots of life sciencey things at the time.
And you've also done a bunch of patent litigation work in the private sector.
Yeah.
All right. So with that, I will have Erica take it away, and I will send you guys if I still have it, your ChatGPT intros.
Oh, that would be funny. All right. So I'm going to go through a bunch of slides and talk about biotech and IP strategy, primarily from the kind of therapeutics perspective, right? And I think Allison is going to touch much more on things that intersect with the software world, whereas we all know life sciences is what we were chatting as people were coming on, moving that way. But I won't touch it all on that actually. These slides will be available to you, so don't feel like you have to take screenshots. I mean, you're welcome to, but you're going to get them as a PDF anyway if you want them. Okay. So, when you're putting, my understanding is this, at least the thing I got from Charles originally was the product profile type things. Where does the IP fit in this? And I always think, first think of if you're a company, and you may not be a company, you may be working with a professor who, is doing something else, but whatever you're trying to make or protect, what is it? Is it a product? Is it a service? Where does it operate in? What is its landscape? Are you treating breast cancer and there are other breast cancer treatments? Or are you doing something so new, there's actually nothing else out there that does the same thing? Of course, what are its advantages and how would you protect those competitive advantages? And that's what we'll chat about today. Like I said, there are a lot of plans you can do with technology, right? You can license out your technology. For example, the UC system routinely licenses out inventions that professors and graduate students and undergrads and postdocs have made, right? And those could go to really big companies like a Novartis, or sometimes they go to startups that either the professor or postdoc or someone even not associated with the university is starting. And then in some cases, you have professors who are coming up with great stuff, but they're going to stay at the university. There are some really famous cases of this. There's Jennifer Doudna, Carolyn Bertozzi, for example, great innovators, lots of inventions. But while companies start around their inventions, they continue to be wonderful professors. So you often need to know what it is you want personally, if it's your innovation, or what the person you're working with, if you're helping them, where do they want to go with this? Because it will influence what their strategy is and how you might be able to help them. Okay. So there are a lot of ways you can help people with innovations, but we're going to talk today about intellectual property, and there's many types. I've listed here patents, trade secrets, trademarks, copyrights, and know-how. I'm mostly going to talk about patents, a little bit about trade secrets. I am not going to touch on the other stuff. It's not that it's not important, but in the world of startups where you're taking something, for example, that just got innovated at the university, some of those other types of things like trademarks and branding will come later, but they don't come up as early in the life sciences as they would in some other areas, or at least in my experience. That's not, there may be obviously exceptions. What I generally do with startups and people who are coming and thinking about what to do with their inventions is really IP strategy. And what that is simply, how do you protect your innovation, right? How do you protect your baby, the thing you made? And can you protect it? It's not always clear for some things that you can. And could you actually go to market with it? Could you sell it? Could you license it? Or is there someone else's IP, for example, someone else's patents that are in the way, like a roadblock? And if so, what do you do about it, right? And it's usually these two things that you need to communicate, for example, to an investor, if you want someone to invest in your technology, or to someone who, like a company that wants to acquire your technology. On the IP side, these are two of the main questions that tend to come up. And so they're good to think about in advance. When I'm working with small startups, and I do that, for example, at IndieBio, which is an example I think I have here on the slide, but I also do it with some folks from UC. There are two, I use IndieBio as a good example for life sciences. It's a small life science incubator that's in the San Francisco area, but there are many, many incubators all over the place, and it's often where startups go after they leave the university. And most of what they're doing at that point for IP is preparing for investor diligence, right? Which is, can I get people to invest in this? What are the IP questions they're going to ask? And when I say call the castle and the moat, meaning the castle is your key inventions, right, that you're trying to protect. And then you're trying to protect some space around them so someone can't copycat what you're doing with just a slight variation really early. And these, again, are two major goals in startup life. When you are communicating IP strategy, such as in a TPP or in a pitch or however you're going to work with your team, what the end result you're going to do, is you have generally basic messages you're trying to get across that we've sort of mentioned. How you're going to be protected from copycats, from someone just simply taking the same thing you've done and reproducing it and selling exactly the same thing, the same product, the same service. Could be an antibody, could be a mass spec method, could be a medical device, could be an ingredient. So think about that. There are many ways of protecting it. One thing I'll remind you many times during this short talk is IP is not the end all be all, right? Particularly in therapeutics and medical devices, there are regulatory barriers that can give you a competitive entry, a competitive edge. There are market entry barriers that keep competitors from easily coming into the field. There are many business aspects to strategy that are important so that IP doesn't drive the bus. So you're going to communicate a plan for protection. You're going to communicate some idea of the landscape. What are your competitive products, but also what is the competitive IP? Do people own patents in your area? For example, say you're doing an antibody and you think, I want to make another anti-PD-1 antibody. Well, there are plenty of companies that have that already on the market and others developing. What does their IP look like? Is it going to, prevent you from going forward, or is it very specific to their antibody and you can make another one as long as it's not identical? So you need to communicate that you don't have red flags going to market. And that can be, there is an issue like a patent, but you've taken a license to it. Like I said, the important thing is to think of it, IP, as a building block rather than the whole house. And, the other thing we're going to move into now is finding a balance, right? And that balance for life sciences, at least the clients that I work with, is often between patents and trade secrets. So we'll talk a little bit about what those are, and how you decide what that balance should be for your particular idea, because it will be different. It will be very different from software to a device that someone can buy and take apart, right, in their lab, or, for example, an antibody that someone could chemically analyze and sequence. All right, so patents. I'm going to give you a very brief overview of patents. One thing I will just put out there and we can talk about, or I'm happy to take questions later, is there is this urban legend that if you have your own patent, means you have a clear path to market, you have freedom to operate. That is absolutely untrue, right? Patents work like Venn diagrams. You may have certain rights, someone may have other rights, and your rights are subservient to them. So while it's nice to have your own patents, they are not going to necessarily guarantee you a way forward to market. That you will have to look at what other people own and whether it's a roadblock or not. So the way I look at patents is think of it more like you're fencing off people from unauthorized use of what you have. You have to think about they're also country specific, right? Like you get a patent in the US, you get a patent in France, you get a patent in China. You can only protect things generally. This is a little bit of a generalization, but things that are going on in that country. So for example, if I have a patent in the US, but you manufacture in Argentina, I cannot stop you from manufacturing in Argentina. I can stop you selling in the US, but you can see how this country thing, can become quite a puzzle. And patents generally last 20 years from filing, although particularly for therapeutics, that term can be extended and altered by regulatory aspects, as well as some things that go on during the patenting process. One thing that comes up all the time is they're super expensive, particularly if you do file in a lot of countries. And so it becomes a big budget item for startups, particularly in the life sciences where they tend to file pretty broadly across the world. You can patent many things in terms of drugs. And I've just given this from a drug overview just because it's a good way of looking at it, but you could make a similar list for any other sort of product or service. But if you had a drug, right, you would patent the key ingredient, provided it was new, maybe how it was formulated into a pharmaceutical. It might be that that's still an ingredient or part of a product, like a combination product. I have a client, for example, that has a combination drug and medical device. You can patent methods of making your drug or in the ingredient and its formulation, methods of using it, and then all sorts of combinations with software and devices and assays. So the take home from that is there is a lot of things you can protect, even if you start with what you think is just one innovation. I am not going to go through the timeline here. I will provide that in the slides in case you're curious of how long it takes to get a patent, typically in the life sciences. I'm going to briefly touch on trade secrets because I think Allison's going to talk quite a bit about that. But generally, a trade secret is something that isn't known and has value, right? You have to keep reasonable efforts to maintain its secrecy. Actually, something that can be very hard to do at a university where you have students coming in and out of a lab, but there's no formal registration, there's no fees. So, but it has it. So basically, the biggest thing is it has to be a secret. So for example, if I want to sell a drug, that's not going to make a good secret because the moment it goes on the shelf, or even if you have to buy it at the pharmacy, a competitor can take it back to their lab and chemically analyze it. It's basically out there. On the other hand, if I have a method of making that drug, right, and I do the manufacturing, in a facility where the public cannot see what is going on, and I never publish the method, that would be an example of a trade secret. One of the biggest things about IP I find, particularly working with universities, is communications and how that balance with IP plays out. And I know I'm touching on a lot of highlights here, and that's kind of what I'm intending to do. So if there are questions about this, I realize we'll have limited time. You'll also have my contact information, so feel free to just email, and I'm happy to answer questions. But you were at a university, or most of you are associated in some way with the university in this program, and ideas tend to come from folks in the university. Universities, right, their main goal is teaching and publishing. So what I often find in working with life science clients is that the professor, the postdoc, the graduate student has already published something related to whatever it is, their innovation, before they start thinking about patents. It's become more common to think about patents, but when I was in graduate school at Berkeley, no one thought about patents. And again, I'm kind of ancient, so the time has gotten a little better there. But you have to think about, if I'm going to the Gordon Conference or I'm going to the Keystone Conference or whatever conference you're going to, the American Cancer Society, what are you talking about? And are you basically giving away your invention before you filed a patent application on it? Usually you want to go talk to the tech transfer office or, whoever's doing the licensing for the university and get their input before you go out and start speaking. There are times where you can protect your discussions with confidentiality agreements so that it can still stay secret. If you're trying to pitch a company and get investment, it's really hard to keep secrets, but there are ways of giving limited detail so that you maintain your IP rights. I'm going to just sort of give you this as a high level. This actually relates to the slide we saw before. It's basically developing layers of IP protection. Again, I'll put this in the slide set, but I'm going to skip over it in the interest of time so that there will be time for questions. And this is where I usually leave it. And I always say, IP should not be the tail that wags the dog. Basically, when you have an idea, going back to the original kind of first couple slides, you need to figure out what you want to do with it. For some people, it's just getting the idea out there. For example, I have worked with certain medical professionals who say, as long as this gets used, right? As long as it reaches patients, I don't care what happens. I'm not here to make money. I just want it to be out there. Sometimes that means publication and speaking engagements at meetings may be the best route for them. Others are, I want this to be out there, but I want to have some control over who goes forward with it, in which case licensing to particular companies where you can choose the company may be the route. And then, of course, there are a number of folks who actually want to start their own company. Even once you've chosen that, right? Really the business proposition of whichever those 3 or 4 options you've, fixed on should drive the strategy. And then IP, right? Your intellectual property strategy should just support whatever that overall goal is. And I say this because after giving talks on patents, I usually have folks saying, well, I just want to, file a patent so I have one, or like my investors are just going to count numbers, like how many do I have? And I'm not saying that's not true in some circumstances, but in the long run, what I generally see when my companies go through diligence and fundraising is, do your patents actually protect your product or service? Do they ward off competitors? And unfortunately, every once in a while, the answer is no to both of those, right? I've had companies that file patent applications and then turn out not to work on whatever it is that they filed on, or it's too narrow. They haven't fully explained their idea enough to get broad enough coverage to keep competitors out. So yeah, this is more food for thought. You will get my email address. You're welcome, like I said, to ask questions by email. But I really wanted to leave some time in case folks wanted to ask general or specific questions now.
Anybody with questions, feel free to raise your hand. Quiet group here.
Yep. Well, maybe after Allison's talk, because I think she's going to talk more fulsome on some of these ideas, perhaps. I realized there was a lot of material, but I wanted to leave Allison plenty of time. So maybe we'll just switch to that, and that will generate questions from folks.
Sounds good. And then, let's hear from Vincent.
Yeah, hello.
Hi.
Thank you. Very interesting. I think one question in my head, especially in this Catalyst internship, I'm always curious about the differences between maybe a big company like Roche or J&J and their process for maybe filing patents or figuring out a strategy versus universities. Because in your talk, it seemed like there's actually a lot of differences. As you said, a lot of university people might not be able to hold secrets as much, or their goal might actually not to necessarily commercialize, but more to just get their idea out to patients. So
Yeah.
I don't know. Is there any
That's a
difference?
good question. Yeah, there
Yeah.
is. There's a big difference. We used to work for a division of Novartis long time ago
Okay.
before I became an attorney. I actually worked as a scientist. Um, and my experience there was sort of multiple fold. It was not in the pharmaceuticals. It was actually in sort of biotech tools area, but they, basically in core areas, they did not allow us to publish at all unless the idea was a dud, right? If it was going nowhere and the project got canceled, they were like, hey, go ahead, go to the meeting and, talk about it. Otherwise, we were generally, everything got filed as a patent application or just kept secret, right? Because we were all under confidentiality agreements about the projects we were working on, right? So that's a big difference from a university, right? When you're a grad student, right? No one says to you, hey, you can't like tell people what you're working on. It's like, at least in my experience. Whereas in
Yeah.
a company, you usually do. The the thing that I find a little different, I mean, there's big companies, right? They're kind of like a huge octopus. I don't know if I should describe them as a huge octopus because they have many parts. They also steer like a cruise ship. And what I mean by that, it's like they make decisions very slowly, generally, especially I will say, since I went through two mergers and a spin out and dealt with a number of different cultures in that, certainly Swiss based ones, because they're very consensus oriented, things happen very slowly. And because of that, that means sometimes that their IP strategy is not as reactive to where the business is going, right? In other words, they accumulate lots of things in their portfolio that they're never going to use, and it takes them a long while to sort of cull down what they want, as well as it takes them a long while to decide that a new idea is really good and they're going to get going on it. When you work with like something coming out of the university, it's headed towards a startup, like it's going to become a small company or it's licensed to become a small company, things tend to move a little, in some ways, faster, right? Because everyone's just sort of gunning towards one end goal, even though the money is a lot tighter.
Okay, no, that's really interesting. Just because I don't know, in my head originally I assumed that because a company might have more resources, more secretive, like maybe they have like a game plan on a whiteboard, they'd be able to get them out faster. But I think your insight really makes a lot more
It
sense.
might be different for different companies. And Allison, you might comment for like particularly for tech companies like Qualcomm, I know like has a ton of patents, for
They
example.
do, and I think IBM is the number one
Yeah.
patented entity in I think at least in the United States, if not in the world. I don't know. My experience, so I was a chemist before I went to law school, and so my most of my practice experience has been same similar sort of veins as what Erica has done. I think every large company I've represented has been sort of a behemoth because you're fighting for resources for a bunch of different projects. And exactly what Erica is identifying, the beauty of university to startup is that you're focusing on one main idea and all of your resources are going towards that. You're thinking about the portfolio for one idea. You go back in the paperwork for some of these companies because they have to document everything. You actually end up and reading it eventually in litigation to figure out how the company ended up developing what they were going to do, and it's years, not months, to figure out what the right portfolio is. And then there's more experimentation, and then you have to figure out, what's the next thing that you're going to file for. Tech companies don't have the luxury of waiting that long. The inventive process is just different. That's a very large generalization, but I feel okay about it for the most part because, you're how many iterations of how many versions of software are you going to have in a year? Depends on how quickly you're moving. This has been exacerbated with AI, which is what we're going to talk about in the next half hour. With let's say you're developing a drug product, maybe you come up with the compound at the university. That's going to be one of your main patents, and you know what that is early on, and you're building around it. And so you know how you're heading forward. For a tech company, a lot of different directions very rapidly, and they've got to make sure that if they are pursuing a patent-based strategy, that they're covering their bases because their competitors are going to be doing the same thing. So different models of innovation, different speeds, I think are two big differences.
You guys did a brilliant job answering that question. Thank you so much. I learned a lot.
Sure.
Other questions at this stage?
Maybe you should jump in. It's a good starting point.
Yes, I feel like that was a great question to ask. All right, let's see if I can get this. While I'm fighting with this, Erica, do we want to handle the question in the chat? Should I file my patent before or after I have my prototype?
Yes. Okay. So interesting question. Sorry, I'm looking at the cat. I look like a cat now. Sorry, but I am not a cat. Um, yeah, I'll answer real quick. Prototypes are different for different types of inventions, right? So if your prototype is a chemical compound, right, you need to know how to make that compound and use it. So yes, you're going to have that prototype. For medical devices where sometimes drawings suffice, you don't have to build the device to actually work. Often people don't before they file their patent application. Certainly for clinical methodology, methods of treating patients, you generally do file before you start treating patients because that's a public use. So if you have a specific question about a particular type of prototype, happy to answer that offline. And I see Allison has her slides, so I will let you go from there.
I've successfully done it. I don't know how I was breaking it before. Erica and I didn't plan this, but it actually is going to end up working out really well. I want to come back to a concept that she had talked about the types of IP, because the way in which these play out with what we're going to be talking about, which is artificial intelligence-based inventions, it actually works a little bit differently, or at least that's what we're seeing so far in this space. I think I'll just take a quick step back and say that, like the answer that I gave to Vincent, the space around patenting and figuring out IP around AI inventions is rapidly moving, not particularly settled. Literally today, the US Patent and Trademark Office put out guidance about how it is that you can get an AI patent. We're still trying to figure it out because all of this is moving very rapidly. And it's, as we were talking about, it's a different type of innovation pathway than what I think it is been more typically coming out of universities, which is more life sciences based. So back to the idea here that, patents, trade secrets, copyright, and trademark. I also am going to leave trademarks alone for the same reason that Erica did, that I think those end up being a larger part of the process later on when you're thinking about branding. But for AI, what we're going to talk about for the most of this presentation is that patents and AI in many circumstances are not a great fit together. The rules for how you get a patent and the ways in which artificial intelligence-based inventions work, they don't necessarily jive. And so what we're starting to see in this space and how clients are being advised is that you kind of have to think outside of the patent box. I think the assumption or the default can always be, as Erica said, I want to get a patent, I want to get a patent. That might not be the right answer here, depending on what you're looking at. And so I've given you some thoughts, and this is all with the caveat that, it really depends on what it is that you're describing and what it is that you've invented. But there are a variety of ways to claim portions of AI-based inventions that may not default to patent. So things like your source code, that can be copyrighted. Things like, a manufacturing process or your know-how for how you developed something that can fit under trade secret sometimes. Your algorithms, and that's really what we're going to focus on going forward, and your training data, the vast amounts of data that you have to use to get your invention to work. Sometimes that fits a lot better under trade secret than it does under patent. And then, stepping back to the life sciences world, oftentimes diagnostic methods may have ended up falling under the trade secret bucket because they don't fit very well in the standard patent bucket, unfortunately. So let's talk about a few more details. So I'm going to dig in a little bit on patent law. We're not going to do anything too crazy here. But I do think it's important to be thinking about why there's a mismatch and what it is that you can do about that going forward. So I'm going to talk a little bit about inventorship. So the idea being that, the people who are developing the subject matter that's covered in a patent, those are supposed to be the inventors. I've given you the statutory language here. I'm not going to torture you with it. Two key points to keep in mind. The first thing is that academic authorship, which I imagine all of you were dealing with in one form or another, is not necessarily the same as who is an inventor under patent law. Sometimes the Venn diagram of that is the same, but oftentimes it isn't. So the definition of the inventor, it's the individual or the group of people who invented or discovered the subject matter of the invention, what's actually being claimed. And importantly for AI, under our current case law and statutes, inventors in the United States have to be human. It's actually not the case in some other places around the world, which has created some interesting challenges. Most inventions are joint inventions. And the idea here is that if you're working on it jointly, you apply jointly. You don't have to work together at the same time. You don't have to work on the exact same things. You don't have to contribute to all the same aspects of the invention. As long as you work together in some way to develop the subject matter that's claimed in the patent, you can apply together as joint inventors. Why is academic authorship different from inventorship? So it's because of a patent law concept called conception. So the idea being that in order to be an inventor, you have to have conceived of at least one portion of the invention. You have to have come up with the idea. It's not enough to do what we call reduce to practice. The easiest way to explain that is that if you're the person who's thinking up the ideas, you're conceiving, that makes you an inventor. If you are the person who's at the lab bench executing instructions from your supervisor, you're not necessarily developing the idea, that's reducing to practice. That in the United States is not enough to make you an inventor on a patent. We've got a bunch of rules in the US for how it is that you can actually patent. So you have to satisfy certain criteria in order to be able to get a patent. Your patent has to be on the type of, so we call it subject matter, but it has to be the type of invention that we've decided fits, that it should be patentable. So usually this is a process, a machine, something that's manufactured, or a composition of matter. So something like your drug, your drug molecule, something like that. It has to be useful, it has to work for its intended purpose, it has to serve a practical purpose. Novelty really just means that somebody else hasn't invented it in the exact same form. There's a lot more complicated rules about that, but that's the basis. We also have an extension of novelty called non-obviousness. So you have to it's really one big step further. So it's measuring something that I think is even more abstract than novelty or utility. The idea is, what did this invention accomplish? And is it a big enough advance over the prior art such that it justifies getting a patent? If that sounds murky to you, that's good instincts. It is murky. Oftentimes, when you're figuring out what's obvious and what isn't, you have to talk to experts. You have to talk to scientists who are working on this stuff to figure out what they understood at the time. And then finally, there's certain rules about what you have to describe in the patent. The idea being that, we have sort of a quid pro quo system in the United States that you get the exclusivity that Erica was talking about. You get to prevent other people from using your patented subject matter for a period of time. But in exchange, you have to describe it well enough in your patent that people can build on it. So, it isn't, you're not allowed to hide the ball in that way. The big challenge for artificial intelligence-based inventions, and just kind of taking a step back, it's the exact same challenge that software-based inventions have had in the United States for a long time, is that they don't fit particularly well within that first category that we talked about, so the subject matter category. You're not allowed to patent what we call abstract ideas, things like algorithms, mathematical equations. You're also not allowed to patent laws of nature and natural phenomena, which can get you into trouble on the more life sciences based side. This makes it very difficult to get patents on software, on algorithms, on those types of inventions, at least in the United States. And so I've made you guys a list of things. There's certain things that you're just not allowed to patent. You're not allowed to patent the process for building a nuclear bomb. But it is very challenging to patent the items that I've listed at the top under our current rules because of the challenges that you have with algorithms, mathematical formulas. There's a variety of other things on here as well. So at least part of the challenge that we face when we talk about patents on AI is that we actually haven't had great test cases yet in courts for anything except one example on inventorship in the United States. So we had one case come through being recorded, but I'll say it anyway. It was pretty clearly a case where the AI had not, basically the human inventor tried to file an application and say that the AI actually did all of the inventing and that the human wasn't involved at all. And that got rejected in the United States because back to our rules on inventorship, as the law is stated right now, inventors have to be human. But the US Patent and Trademark Office is allowing significant number of patents at this point with AI contributions, but you have to list at least one human on the inventor as an inventor. And so the analysis of whether or not the inventorship requirement is satisfied really boils down to some language about you have the humans who are inventors have to show that they made a significant contribution. They have to show that the AI itself wasn't doing all of the thinking, wasn't doing all of the inventing. As our technology stands right now, probably okay on inventorship at this point. I keep getting told by people who are experimenting in these spaces that we're not super far away from situations where inventorship is going to be very, very murky on these patents. But for now, you can't list the AI as the inventor. You've got to list the humans who are working on it. But you absolutely can seek patents using AI as a research tool in order to develop a particular invention. There are a whole host of other challenges that have not been tested in court yet. Lots of people writing law review articles and doing scholarship on it, but we just haven't had the right cases come to court quite yet to probe some of these things. So on novelty, AI is actually going around and creating a ton of potential prior art, which makes it pretty difficult to invent in these spaces. Have you invented something new? If ChatGPT has been churning a whole bunch of stuff that's similar and there's some way of publishing it, that becomes challenging. For both obviousness and disclosure, the way that we measure is through a standard, we call it person of skill in the art. Basically, I think you guys on the call are more than likely persons of skill in the art in your particular areas. You have expertise, you've been working in the space, you understand what's going on in the field. So the idea, would it have been obvious for somebody to use the AI as a tool in the way that's described in the patent? But that gets kind of shifty in the sense of you have to think about, how does the AI's influence play into how you think about the person of skill in the art? Is that, a person who's really good at AI and who's also doing life sciences work? That isn't necessarily what the law says at this point. We don't have a clear answer for that. Same idea on disclosure. You hear a lot about how AI is black box and how you don't really understand how the AI is coming up with the output that it's coming up with. Do you have to be able to describe all of that in the patent in order to get a patent? Unclear. I think that would be a very challenging standard to reach. So, it's a murky space. That is not stopping people filing for patents on this, but I just really want to make it clear that it is not clear how these issues are going to play out, and there is risk there if we're stepping back to Erica's presentation about strategy.
Allison, I have a question, if you don't mind me interrupting.
Oh, yeah, of course.
So, you talked about using AI as a tool, and there's a lot of, at least a few, drug target sort of development companies that are using their own AI to find targets.
Yep.
What happens? How do you resolve a dispute if two companies ran their algorithms separately, came to the same target? Do you then go by which one filed the patent first? Whose AI spit the answer first? Like, how do you resolve that dispute? Because they didn't get each other's data, right?
That's a great question, and I'm going to give you a very lawyerly answer. It depends. In that particular scenario, there's a couple of different things to think about. So if they're both using algorithms to come up with the same drug target, if you're patenting the drug target, regardless of how you developed it, doesn't really matter whether you were at the wet bench or using the AI, whoever is the first to file, whoever gets the patent office first is going to win that fight. It used to be in the United States that whoever was the first to invent would win that novelty fight. But that gets really messy really quickly. That's why, if some of you have investigated patents, you may have been told in the past that you need to keep really good lab notebooks. Because and actually there is a significant litigation around the CRISPR technology that came out of UC Berkeley, where there's a large fight between them and the Broad Institute about who invented first, and they literally were back in the lab notebooks trying to figure out. It was a matter of weeks try to figure out who came up with it first. We've simplified that a lot. The rule now is whoever is first to file. A couple caveats that aren't relevant to your question. The second piece of what you're trying to figure out here is, what do you want to do in that situation? The drug target itself, the molecule that you come up with, or the protein, that's going to be patentable. That is a composition of matter. That's patentable subject matter. You're not really going to have an issue with that in terms of the patent office. Whoever files first is going to win that one. What do you do about the AI algorithm is the second piece of the question. And a lot of companies are not going to file a patent on the algorithm, because the problem there is that if you file a patent, you've got to disclose what you're doing. You got to disclose it well enough that somebody else can do it. Are you better advantaged from a strategic perspective as that company? You got to patent the drug target, because you want to be able to have exclusivity on that. That's the piece that's going to get licensed to the startup company, licensed to the big pharma company to move on. Do you want to disclose your algorithm, even if you can get a patent? There are a lot of companies that are saying no. And I've worked with, we have a program here at the law school where we're providing freedom to operate, as Erica talked about, to some early stage startup companies. And I've worked with companies who are in that dilemma, and they're foregoing patent protection on the algorithm piece because it's not a great fit. They don't want to disclose it, and they're changing it so rapidly. There are different iterations as they're putting new training data in. Their model shifts, their weights are changing. And so it ends up becoming incredibly inefficient for them to go forward in that process and to try to patent. They just say they keep it as trade secret. You can license trade secrets, you can absolutely transfer them as you need to the startup company or to the large pharmaceutical company. There are some challenges with that, which I'm going to talk about in a minute. But I hope what I'm highlighting here is that it's a different strategic set of questions that you have to ask about what it is. And it's a great question, because I think this is what a lot of companies are struggling with right now. So what do you do?
And you can just do a yes or no with this one. So if one company files first, but the second company kind of came at it at the same time, sort of what happened with CRISPR, is the second company now precluded from using that drug target because they were second?
In theory, once you got an issued patent, yes.
Okay.
In practice, what's going to happen there eventually, they will probably go fight about it in court. And then what will happen at the end of that litigation is the settlement agreement is going to license that invention to the second company and will allow them to use it. So there's a big advantage in winning the race to the patent, but the economic markets eventually will resolve it, although the second inventor is going to be kind of bummed about the result there.
Yeah, and I'll just jump in here and say, in terms of one thing that has changed very recently is, particularly in the US, is targets, right? It used to be you could practically patent a drug target. I'm going to patent everything that inhibits PD-1, and that's really becoming less and less possible at this point, that you actually are just going to get coverage on what you use, your class of inhibitors, or even a subcategory or a subgroup of inhibitors that you've shown work. So in some ways, if two groups arrived at the same target, the target might not be as valuable as actually finding what hits the target.
Yeah, we had a pesky Supreme Court case that caused that problem. So, and it's actually a reason why the trade secret piece of this is becoming more important, especially for biologic areas where there are complex drug targets. Where I've talked to folks, I'm sure Erica's dealing with this as well, where trade secret protection may become more attractive in certain situations, because maybe the inventive part was figuring out what the target was, rather than figuring out what the compound is. And so that, do you want to tell everybody what the target is? You might have to in order to get a patent. Here's this compound and here's this target. You might have to do that, but maybe that's not the right answer from a strategic perspective. So in the interest of time, I'm not going to spend a ton of time here, but you guys will get all of these slides. given you my thoughts on the specific features of the algorithm and what you might want to be able to do. The takeaway on this page, I was pretty intentional about the use of the word may. It is a lawyer weasel word, but I think it's accurate here. I think outputs and end products, it depends on what it is, but perhaps the most reliably patentable thing on this list. Algorithm's going to be challenging. Training data, can't really patent data, might be able to patent how you've structured the data. But from a strategic perspective, stepping back, for a lot of companies that are AI based, that training data or the way that they've put the data together, that might be the most valuable thing that they have at the early stage. Do you want to disclose what you did? There's a real advantage to you from a monetary perspective of being able to exclusively license that to somebody who's got to pay a premium to get a hold of it. The way in which you're using the model, you've got to give a lot of description about how it's going to be specifically applied in order to be able to get that. But still, we're in a little bit of the wild, wild west here in terms of how all of this is going to shake out. So a few other thoughts on this front. If there are features of your model that are easy to reverse engineer, we'll talk about this more with trade secrets in just a second. You're not violating a trade secret if you reverse engineer it. You are absolutely allowed to do that. And so if there are features of what you're doing that are easy to reverse engineer, you might need a patent in order to protect it because you can't rely on trade secrets. And I think we've talked about some of the rest of this. How long do you need protection for your invention? When you guys take a look at Erica's slides, the timeline to get a patent is not short. We're talking on the order of years, not months. And so with the speed that AI-based inventions are moving, how long do you need protection on that particular algorithm or the particular way that you're using it? Or are you going to change it in 2 months? These things aren't necessarily fixed in time. It's the same argument for data. Your data set's going to continue to evolve. Patents are really great when you can use them at a fixed point in time and you're protecting a specific thing and then a sort of a moat around it. Are you creating a ton of versions? And then a biggie, and Erica hinted at this, and I want to emphasize it. How much money do you have to prosecute multiple patents? The thing that a large pharmaceutical company can do, they got a lot of money. And so they can go patent around everything. That sometimes is part of the reason why it takes so long is you got to figure out exactly what iterations you want to do. If you're a startup company and you're sitting on a couple $100,000, do you really want to be spending that money on prosecuting a bunch of patents, or do you want to be really working on your proof of concept? So considerations to make here. So I'm going to skip ahead a little bit here to this trade secret question. And so as Erica has talked to us about, economically valuable, not generally known, you have to use reasonable efforts to keep it secret. It can last forever. The Coca-Cola formula is a trade secret because they have done a really good job of hiding it and nobody's figured out what it is. You do not want to disclose a trade secret. The disclosure destroys the trade secret. One of the biggest challenges from a litigation perspective, and I think it's one of the hard things about thinking about trade secrets, it's really hard oftentimes to identify exactly what the trade secret was. And this is the biggest hurdle that you get over in litigation, is really trying to figure out what the scope of it is, because it's risky to write down a whole bunch about it. You have to really carefully control what it is that you are trying to control in this way. So if you want to sue somebody on a trade secret, it's not exactly the same thing as what you're using with the patent. And so when you go to patent and litigation, you're trying to find somebody who infringed, who used what you have claimed. That's what in the law we call a strict liability offense. If you did it, you're guilty. Here, you can't sue for infringement of a trade secret. You have to sue for misappropriation. So that's an acquisition of a trade secret by someone who knows that they got it in an improper manner. So if you're thinking about things like, hey, I signed an NDA and then I went and I shared this with my buddy. It's those types of things. You used improper means. You did improper things in order to get the knowledge. You got it from somebody who stole it. You knew that there were NDAs floating around on it, or you knew that somebody accidentally gave it to you. So variety of examples, both focused on AI, your training data, how you're structuring your model, the types of formulas that you're using, your methods. But trade secrets are important more generally in the development of your company as well. So things, your customer list, you don't necessarily want that getting out. The manufacturing techniques or refinements that you're using that maybe you didn't put in the paper, that maybe you didn't describe when you went to the Gordon conference, but that are really important to make things work. Your experimental data, patent applications that haven't published. So patent applications, when you file them, they don't usually become public immediately. There's a wait period. Your business plans. Biggie in the scientific space is negative information. What didn't work? What have you learned by probing around and figuring out what doesn't work in a particular space? So got a list here of things that we would advise in private practice that you should be doing. But basically, it all boils down to being really smart about how you're protecting these types of trade secrets. So I just want to highlight, and I think we should probably switch over to questions, but I put together a little chart for you guys of different comparisons and then a variety of different strategic issues that you may want to be thinking about. And I encourage you to take a look at it. One of the biggies here, and then I'm going to go ahead and open it up for questions, is this question of detectability. How easy is it to figure out if somebody infringed your patent? That's a biggie that comes up in the AI space. Patents work really well when you can either detect what goes into the AI system or oftentimes what comes out of it. Like the question that Sahila asked, if you know what's going to spit out the other end is a drug product, that's the type of thing where patents work well because you can figure out if somebody's using the drug product. It becomes a lot harder to figure out if they're using your AI model in exactly the same way. So happy to open it up for questions from anybody. My presentation, Erica's presentation. Yes, Anne.
Hi, thank you so much. That was super, super informative and interesting. My biggest question, and just out of curiosity, you explained you can't necessarily claim a patent, it needs to be human. I was wondering, what are the incentives for a non-human patent or other places where that has been allowed? Like, what is the incentive for that?
To be honest, so the case is called Thaler versus Vidal, if you want to go take a look at it in the United States. But the inventor's name is Stephen Thaler. He basically floated his case as a test case around the world. He was kind of making a point and trying to show that the systems were going to play out a little bit differently. And I think in South Africa, for example, he was granted a patent, if I remember correctly. I think in England he wasn't. I think part of the point there is that we're at the stage of development with AI technology where we're getting pretty close to the AI being able to operate independently. But at least at this point, there's going to have to be human involvement in prompt engineering and figuring out what the direction is to the AI. Don't quote me on this, but based on the United States Patent and Trademark Office guidance, I think in many cases, at least for now, that's going to be enough human involvement in order to get you a patent if you can get over the other hurdles. I think, Thaler's an interesting character. If you got 30 minutes, he's worth a Google just to kind of see what his philosophy was. I see Erica laughing because she knows what I'm talking about. He was trying to make a point. He was trying to float a test balloon, but his technology wasn't really close, is the way that I understand it. But I think we're getting closer all the time to a situation where this would come up. And then the question is, well, do we need to change our laws? Should AI inventing without a human involved be worthy of a patent? That's a really big question. I have real concerns about that. And I think my biggest concern is probably process. That's going to really gum up our patent system. We're going to have an enormous number of applications and patents coming out. It's going to be very difficult to navigate. We're already dealing with some of these problems with AI as a research tool.
And then who owns it, right?
I was
So
just
if a
going to say that,
computer's
yes.
inventing it, right?
Right.
Is it the person running the software, who wrote the software, who started off this algorithm? Or is it like the person who did on it? Is it no one? Does no one own it? Does the computer own it? Is the computer going to pay taxes?
That's
I mean, I think that was
Yeah.
that's the essence of Anne's question probably is what's the reason? Why would you even want your AI to be on there? Because are you going to give your AI royalties? Are you going to claim extra royalties for the AI so you double dip?
I don't think you want it in charge of patenting. I think from a strategic view, what if there really is no human involvement? What, kind of the inverse comes that AI becomes the inventor. We're going to have to figure that out. We're going to have to figure out how to assign those rights. And because maybe AI is going to take over the world and it's going to do its own licensing, but I think we're a little bit further away than that.
But it could also do patenting, right? So the patent office could have an AI where you file your patent and then the AI on the other side decides whether you get your patent issued or not.
Yeah,
so there's no human involved at all.
That's already happening a little bit. It's not, patent AI isn't taking over the patenting process at the PTO, but it's absolutely being used on a regular basis.
We have one more question here, Mila.
Hi, Allison and Erica. Thank you so much for those presentations. They're so interesting. I was curious if intent falls under the patent or trade secret process. For example, like if you developed a surgical tool for use in cardiovascular surgery, but someone else can copy the design and say it's a paperweight or anything like that.
You want to take it or you want to?
I'll take one attempt at it, then you can.
All right.
It depends how you patent it. Let's say I patent this device, right? And I say it looks like this, right? And it doesn't work with my background, but it's square and it has a button on it and it, has this light or whatever. Then anyone who makes that same device with that same design, doesn't matter what they use it for, right? That's going to be infringement, right? Even if they didn't intend to. There is no intent in infringement. You can accidentally infringe, you still infringe, right? There is no like, oops, I didn't know that. On the other hand, if you had a method of use, like your claim was a method of using this tool, right, to like do surgery, and then I use the same tool, let's say, to repair a refrigerator, I would likely not have a problem.
Which, to be honest, is we usually think of that as a very small hurdle in patenting because why would you patent something that's not useful? But on a life sciences invention, you're probably going to say, here's my drug molecule and I can use it for treatment of these 5 types of cancer. And you have to make some sort of showing that you can actually do that. It's usually pretty preliminary. There can be arguments that say, okay, well, now I'm going to use it as a paperweight. You didn't claim that originally. Those don't always work out the way that you think they're going to, because you end up fighting a lot about what exactly was the intention in the patent. But the idea is that we're trying to not have people gum up the whole system by being able to claim way more than what it is that they actually invented. And part of that is saying what you're going to use the invention for. You're supposed to say that in the patent. You don't always, and that's when you end up in court fighting about it. But that's the goal.
And I heard this at another presentation on IP. Maybe it might have been you, Erica, so forgive me if I'm not crediting you properly. But there was this idea of like, when you claim uses for your technology or your invention, you don't want to go too far beyond things that you can't prove because that will result in rejection of your claim. So that's where it also becomes.
Well, you can also create what I call a prior art bomb, right? So say you get your compound, right, your drug, and you're like, treats Parkinson's disease. But instead you claim like it treats basically everything, not Parkinson's, cancer, whatever. And like Allison said, you don't have any data towards that, right? So maybe you get your claim to Parkinson's if you had some like mouse model or something, but there's no way you're getting claims to like cancer and other diseases because you had no data. Then let's say 3 years down the road, right, your patent application has published and you suddenly actually get data about that cancer, right, or a different cancer or a different disease, and you try to file a new patent application. The patent office is likely going to say, hey, your earlier application already disclosed this. It's not new. Even though you're not getting a claim from it, you still managed to shoot yourself in the foot. So yeah, it's one of those things where I always tell people, don't try this at home, right? There's a reason there are patent attorneys as a profession, just like you go to a medical doctor for most medical things. There's a lot of strategy and expertise and experience that goes in, like Allison was saying from her experience in litigation, where you kind of know what's coming down the path, right? And you need to plan for that. And you want that expertise to help you instead of like filing what I call the ham sandwich of things at the patent office.
All right, we are at time. I'm not seeing any other questions or raised hands, so we can end here. Thank you both so much. This was really great. And as always, we learned a lot. And we can end here.
All right, thanks. Thanks. It was a lot of fun.